Now, the Public Protector's impeachment process is once again in the spotlight. On Monday, the Apex Court will hear if the appointment of a judge to the panel looking into Mfundo Mababane's fitness to hold office is compliant with the separation of powers doctrine. In July, the Western Cape Division of the High Court dismissed Mababane's bid to have the rules for removing the Public Protector declared unconstitutional. Now, for more on this, let's bring in Casper Badenhorst, a senior associate at Ulrich Roux and Associates. Casper, thank you very much for joining us this afternoon. Now, this is a very interesting matter here. We know that Mababane was dismissed in the Western Cape, but there were a few concessions there. If you remember what the judges said about the desirability of having at least a judge or judicial official as part of the panel. But before we get into that, let's talk about the Constitutional Court itself, direct access. Do you think it could be granted in this respect, although she's looking for conditional, although other parties are looking for direct access in this respect?
Yeah, well, I think, in this matter, certainly the issues that need to be dealt with now that have been raised by the Western Cape High Court, that is particularly the issue on the appointment of the judge, that being unconstitutional in respect of the doctrine of separations, and then also her right, or at least the reason why her right to legal representation has been refused almost outright. Those aspects certainly will be issues that the Constitutional Court will need to deal with due to the fact that the Western Cape High Court has dealt with that aspect and being unconstitutional already. So certainly those aspects will definitely be entertained during the hearing on Monday.
Mm-hmm. So you foresee, I take it, that they will be granted that direct access?
I believe so. I think that there will be, it is certain aspects. The point being is that there have been case law and certainly quoted by the Public Protector's legal counsel in respect of, case law that has been quoted in the past as to why these very aspects that they are dealing with and why it's unconstitutional. There's already been issues raised on that. And that is why I believe the entire aspect of what they are doing in terms of the parliamentary process needs to be finalized again in respect of a constitutional ruling.
Mm-hmm. But some could argue that if they're going directly to the Concourt, they're going to limit, or she in particular is going to limit her remedies, because if it's there, it's final now in this respect.
Absolutely. I think we can certainly say that if you look at the judgments on the former president and what had happened there was the whole issue of going direct, which was the commission going directly to Constitutional Court, and that process having limited any appeal thereafter, which is certainly a problem, and it seems to be pandemic at the moment. There's always a first step directly to the Constitutional Court, and thereafter there is no appeal process to deal with what the judgment states.
Mm-hmm. And then to the challenge itself. Here she's challenging her right to legal representation, which she feels was infringed upon. And then she's also challenging the aspect of the judge being brought in as a panel member. If we started with her legal representation, I know the matters are not necessarily the same, but if we look at Hlophe's matter, where they were looking at the misconduct, he was able to have legal representation in that matter that was overseen by the JSC. Now, in that instance, for the benefit of the public, can you take us through the differences in these two situations that would then prohibit her having legal representation in that process that's to take place in Parliament?
Well, you see, I think it's commonplace for people in positions. So, for instance, Judge Hlophe, and where there's a misconduct trial, it's commonplace to have legal representation to represent you. And that's why this whole issue surrounding why she's been barred from having legal representation is being brought to the fore. The issue raised, take, for example, a labour dispute. If there's a dismissal within a labour dispute, the initial step in respect of the hearing, the internal hearing, you're not necessarily entitled to legal representation. However, that can be waived. Now, the issue that's been raised in respect of the public protector is that the rule adopted by the Parliament on the removal outright refuses her the ability to have a legal representative present to be her voice. And that is particularly the issue. There's already been case law. As I mentioned, it's been quoted Hamata versus the chairperson of Peninsula Technicon. And in that case, it was stated that to refuse a person legal representation won't hold any water. It won't happen because it is commonplace to allow people of certain higher positions to have legal representatives. And that is why I say, I mean, if in a misconduct trial for a judge or magistrate, they are permitted to have legal representation. So the question is why, in this instance, is the public protector not permitted a right to legal representation? It's not necessarily a question of whether it's unconstitutional because there is no outright right to legal representative, but it is more whether it's completely unfair that provision in terms of the procedure to be followed has been adopted in such a way that it completely cuts off her hands in order to appoint a legal representative to be present.
Now, judging by what you're saying, sorry for that, but now judging by what you're saying, it means that at least on that aspect of a challenge, she should go fairly well, that perhaps she will be granted that right to have legal representation. Then to the other aspect now, when we talk separation of powers here, where we have a judicial official sitting on a matter such as this one, which will be headed by a legislative arm, as in Parliament. Is there really a conflict in this respect? One, we have Besin Kabinde, who is no longer an active judicial official, sitting. Is it really something where the Concourt will hear her here? Particularly because if I looked at the judgment, I read what one of the judges had said, that he viewed that it was undesirable or at least there were no reservation that it's undesirable for a judge to be part of this independent panel. The process is politically charged. That statement was an interesting one because if we had to compare it to state capture, for instance, it's a politically charged inquiry. But we've got even worse, an active judicial official that's sitting and overseeing that process. So what do you make of those comments by the judge of this aspect perhaps being undesirable?
You see, just the one difference in between the Commission and this process that's being led by the Parliament. The Commission is instituted in terms of certain legislation, which gives that Commission powers, the same powers as a High Court, and that's in terms of the Commissions Act. Whereas this process and the decision-making process of whether a head of a Chapter 9 institution should be removed is a parliamentary process because
yes.
they are directly, they're directly accountable to Parliament. And it's quite right what you say and what the judges have opined on, I mean, in terms of it being very politically charged. It is. You're right that the Commission, just in the same way, is politically charged, but the processes themselves have very different foundational establishment, whereas, as I say, in terms of an act that allows that commission to act as same as a high court, the superior court, whereas this is a parliamentary issue. And that is why the point is taken in respect of the separation of powers. You know, again, case law has been given on this that judges, it's not to say that judges are not permitted to sit on any panel or any commission whatsoever. There are certain times when it's appropriate for them to not participate, if I could put it that way. And that is the entire problem here.
But is it not casting aspersions? Apologies, yes, apologies to interject. But is this not casting aspersions on the independence of these judicial officials? If we're going to say, because there was a part where he talked about this matter is in fact one that is born from several judgments through the course of her tenure. And then from those scathing judgments, we had the Democratic Alliance bringing up this matter in Parliament. Now, if you're going to have a judicial official overseeing this process, somehow they're of the view that it taints the process. But does it really matter if it's born from judgments from judicial officials? Because, I mean, even when you appeal, it's one judge who has his judgment and you appeal it with another judge. And it's because we assume they are independent.
Yeah, so it's more of the, keeping the judges objective. And it's really more of a protection towards the judiciary in itself. It's not to say that the particular judges involved have any bias or any are not being objective in their process, but it is more to ensure that there's a protection for the judiciary put in place, because each section, the judiciary, legislature, and executive, those need to be seen as completely separate and independent from one another. So there are, of course, sometimes where they cross lines, but it's not to say that the judges involved will have a bias towards a certain individual, but it is to ensure that there's protection given to the judiciary in its entirety, that it isn't perceived and to be seen as being a tool for the executive or the legislator. One must ensure that there isn't any imbalance in those three spheres.
No, fully understood. And then just in closing, the retrospective application of the law, I know she's also challenging that aspect. Is there any legitimacy to that argument where she's saying you cannot apply it retrospectively? These were incidents that occurred and then you had the rules set out. Is it not a situation where the Constitution had made provision for the removal of an office bearer, but there were no rules? I don't know, just clarify for us there.
Yeah, look, that will be an interesting argument to hear. It is that they argue that these rules were put in place specifically to have her removed. That's the idea behind the arguments. Yeah, that will be an interesting one to hear, to see what they'll come up with in terms of whether they can apply it retrospectively.
No, very interesting. Thank you very much for your insights. We'll keep a lookout for that matter tomorrow at the Constitutional Court. That was Casper Badenhorst, Senior Associate at Ulrich Roux and Associates, talking to us on the matter that will be in the Constitutional Court tomorrow.